Welcome to Employment Bite. In this series, our London employment team provide bite-sized overviews of some of the key developments surrounding the employment law landscape in the UK. Whether you're an employer or employee, join us for a discussion navigating the dynamic world of employment law. I'm Anvita Sharma, and I'm joined today by Ed Bowyer. Together, we're going to explore how employers should prepare for the duty to take reasonable steps to prevent sexual harassment in the workplace, which comes into force on the 26th of October. So first things first, Ed, what is sexual harassment for these purposes?
It's important to remember that the new duty only applies to sexual harassment, and it's not a wider duty to prevent harassment related to any of the other protected characteristics in the Equality Act. So sexual harassment is defined as unwanted conduct of a sexual nature, and the conduct must have the purpose or effect of creating an intimidating, hostile, degrading, humiliating, or offensive environment for the employee.
So does that mean that employers can ignore the other protected characteristics?
I wouldn't go that far. An employer isn't obliged to take other protected characteristics into account when preparing for the new duty. But of course, most employers won't want to take harassment on one ground more seriously than another. So we think in practice, most employers are likely to consider and refresh their approach to harassment in the round. So not just sexual harassment. Having said that, there will be specific steps that employers do need to take in relation to sexual harassment to show that they've complied with this new duty. Now that probably is a convenient time to discuss what happens if someone doesn't comply. So back to you, Anvita. Talk us through the consequences of non-compliance.
Employees can still bring tribunal claims about sexual harassment in the normal way, so there's no change there. However, a tribunal will now be able to increase compensation in a successful claim by up to 25% if it doesn't think the employer complied with the preventative duty. The uplift will depend on the extent of the employer's failure. So an employer who's done nothing to comply might expect a full 25% uplift, whereas an employer who's taken some steps will be able to argue for a lower figure. There's also a risk that employers could face an uplift in an ordinary harassment claim if it involved to any extent sexual harassment, although it's not clear at this stage how tribunals will interpret that provision.
In your view, is this increased compensation the most significant risk that employers are going to face?
No, I think the real significance is the EHRC's ability to enforce the duty. So if the EHRC has reason to think that an employer isn't complying, it can investigate the situation and use its enforcement powers. It could find out about possible breaches in different ways, for example, because an employee blows the whistle or an employer loses a sexual harassment tribunal claim.
You mentioned enforcement powers then. Can you remind us what the EHRC's enforcement powers are?
They are pretty extensive. As I mentioned, the EHRC could investigate a potential breach and then issue an unlawful act notice. It can also require an employer to prepare an action plan showing how it will comply with the law in the future. However, it cannot fine employers for failures. In practice, I would say it's more common for the EHRC to enter into voluntary agreements. An employer basically agrees to take certain steps to ensure it complies with the law, and then the EHRC monitors its compliance over a period, typically a couple of years. Steps could include things like redrafting policies or ensuring that all staff are properly trained on harassment. And these agreements often get media attention. In recent years, Sainsbury's and Fuller's, amongst others, have been in the news for entering into agreements over sexual harassment. So another concern for employers is the reputational consequences of EHRC action. And that takes us to what employers should be doing now to minimise the risk of non-compliance when the law comes into force. So, Ed, what has the EHRC said about that?
So there's still a question of watch this space. It's been reported that the EHRC will publish updated guidance in September. Now, of course, that does not give employers long to prepare before the duty comes into force. So we think that that means that the EHRC's 2020 technical guidance on preventing sexual harassment is still going to be the starting point for employers when thinking about preparing for this new duty. So employers may also want to review the EHRC's shorter Preventing Sexual Harassment at Work guide for employees, which does contain some useful tips, and it's a shorter read. Now, we don't think that the revised guidance will change substantially, although it will have to address what the EHRC sees as the difference between taking reasonable steps and, differently, all reasonable steps. Because the new duty requires employers to take reasonable steps, whereas the existing guidance looks at the issue from the point of the employers taking all reasonable steps when they're thinking about defences to harassment. So there is that nuance and difference there.
That's really interesting, Ed. Thank you. And do you have any sort of top tips from the existing guidance that you'd be happy to share?
I would be very happy to share them, yes. Now, the existing guidance and the tips, if you like, run to around 25 pages. So we don't have time to look at all of those, but I would distill them down to 5 key things that employers should be thinking about. So first, employers should be reviewing their policies. Very important. Secondly, they should be thinking about how employees report harassment. Thirdly, again, very important, refresher training when it comes to harassment issues. So not only having your policies, but thinking about training staff on those policies. Fourthly, reviewing how you respond to complaints as an employer. And then lastly, considering how you show that your policies are effective, if asked or if challenged. So unpicking those, the starting point is obviously going to be reviewing your harassment policy. And in particular, thinking about whether you want, on the one hand, a freestanding policy on sexual harassment, or alternatively, will you deal with sexual harassment as part of your overall harassment policy?
Do you have any views on that?
So our experience suggests that most employers will have one single policy that deals with all of the different types of harassment. And we think that there is no reason to change that approach. That said, employers, if they do stick with the one policy, will still need to make sure that the policy calls out some of the issues that relate specifically to sexual harassment. And on that point, I would recommend that employers compare their existing policies with paragraph 5.6, so that's paragraph 5.6 of the technical guidance, as this reflects what the EHRC expects policies to cover. So that's enough on that point. Let's turn to reporting procedures. What does the EHRC expect here?
The key message is for employers to be proactive about identifying sexual harassment within their organisation. It's not necessarily going to be sufficient to simply wait for employees to raise concerns. So I'd really encourage employers to think about how else you might be able to get that information. That could be through staff surveys, telephone or online reporting lines, potentially anonymous reporting lines, or exit interviews. What you're really trying to do here is to build up a picture of where there may be issues and why, so you can decide how to deal with them. A harassment strategy will not be effective if employees don't know how to report concerns. So it would be also worth thinking about how your policies are publicised. Simply sticking them on a corner of the intranet may not be enough.
Understood and very helpful. Now, as I touched on earlier, training is going to be another very important aspect of this preventative duty. So what's your advice to employers on training?
I think the key takeaway here is do not assume that one size fits all. Every business is different in its size, its complexity, its risk factors. What drives unwanted sexual conduct in an office environment may be different from what drives that behavior in a hospitality context, for example. So the first step is to identify the risk factors for your business. Then you need to decide how to train employees. Training may need to be tailored for seniority or job function to maximize its impact. It needs to be included in induction processes, but also reviewed and repeated regularly. Employees with management responsibilities need training on how to react if someone makes a complaint. And all employees need to understand that they won't be victimized if they complain about sexual harassment, and that there will be consequences for employees that victimize those who complain. So Ed, could we talk a bit about responding to complaints and showing that policies are effective before we finish up?
Absolutely. So policies should and will, we think, include details of how employees can raise harassment complaints. But the key thing we think is workplace culture also needs to encourage employees to speak up. So if managers know how to support employees, they're far more likely, we think, to feel able to complain. Now, you'll also need to consider how to respond if an employee raises an issue informally but doesn't want to take it further. Now, we see a lot of this. It's not a new situation, but how you react to those very tricky challenges is going to be important in the light of the new duty. Now, one point raised by the EHRC guidance, which I'm not sure happens very much in practice, is the need to train those investigating complaints of harassment so that they understand the issues and how to investigate them properly. Now, the more serious the allegation, the more important this issue is going to be. So by way of example, the technical guidance says that if a complainant has suffered trauma because of their experience, the investigator should be trained on how to question them in a way that doesn't compound the trauma. Now, finally, employers should have processes in place to review their policies and procedures regularly to ensure that they are effective and that they are up to date. Now, that includes considering if changes may need to be made in response to successful complaints, and also using data to spot trends that might indicate a need for amendments to policies or procedures. So making sure that your review process is adequately documented will be important. And by way of guidance, the EHRC policies suggest that policies should be reviewed annually. So before we close, a quick question on NDAs, and that is the non-disclosure agreement, or gagging clauses, as they're sometimes referred to. It's such a hot topic, we can't leave without touching on those. So Anvita, final words, what is the current position on NDAs?
I think that they're best viewed as permitted but frowned upon by the EHRC because of the risk that they are used to cover up bad behaviour. The EHRC guidance says that they should only be used where necessary and appropriate and in line with best practice. So there are various matters that need to be carved out from confidentiality provisions, such as the right to report potentially criminal conduct to the police or regulators, or the right to discuss the situation with medical professionals. Now, the outgoing government has said that it would legislate to make those formal legal requirements, And it's at least possible that the Labour Party will take action, possibly including an outright ban on the use of NDAs if it wins the election. But in the meantime, our advice would be use them with a degree of caution on a case-by-case basis and not as a default. So that brings us to the end of today's Employment Bite. Thank you for joining us, and we'll be back with another bite after the summer break.